Hi, my name is Abhishek and I'm a legal intern at LEXIS and Company. So today's my topic is CARLILL versus CARBOLIC Smoke Bowl Company. Let us talk about the facts of this case. The CARBOLIC Smoke Ball Company advertised in the Pall Mail Gazette about their product. The smoke ball, in the advertisement, they promised to pay £100 as a compensation to anyone who contracts influenza after using their ball 3 times daily for 2 weeks, as per the instruction printed. The advertisement also stated that they have deposited £1,000 with the Alliance Bank as an assurance. So Mrs. CARLILL, the plaintiff in this case, after going through the advertisement, purchased the smoke balls and used it as for the direction, but subsequently caught influenza. So the plaintiff's claim was refused by the defendant, and therefore she brought a suit against them for the recovery of the amount. So let us talk about the procedural history of this case. The lower court passed the order in favor of plaintiff, and thus being aggrieved by it, the defendant filed an appeal. So in this appeal, there has been 4 issues. Number 1 is whether the advertisement was a promise or a mere puff. Second one, was it a binding contract? Number 3, was Mrs. CARLILL required to communicate her acceptance of the offer to the company? And fourth one is, did Mrs. CARLILL provide any consideration in return for the £100 offered by the defendant's company? Now let us talk about the defendant's contention. On this case, the defendant argued that the advertisement was a mere puff and not a promise. They contested that the advertisement was too vague and without any time limit. In addition to this, they said that there was no way to ascertain whether the ball had been used by the consumer. It was also submitted by them that it was not a valid contract, as the essential element of a contract is communication of acceptance of the offer expressly or impliedly or through a performance of some overt act which the plaintiff didn't comply with. So further in this, the defendant stated that it was a bare promise without consideration. So let us talk about the plaintiff's contention. The plaintiffs argued that the advertisement was not vague. The construction of the offer made it clear that if the ball were not effective, the company would give £100 to the consumer, and in order to facilitate the same, they had deposited the money in the Alliance Bank. Hence, the act of depositing the money proves their intention to enter in the contract and constitutes a promise. So on this, the court held that the Court of Appeal that the plaintiff is entitled to claim the £100 from the defendant, as it was a binding contract with valid consideration. The reasoning given by the court is that the advertisement is a promise. The statement in the advertisement, £1,000 is deposited with the Alliance Bank. Showing our sincerity in the matter clearly proves the sincerity of the defendant to pay the amount and cannot be contrived in any other manner. Hence, it's apparent that the advertisement is not puffery but promise. Second one is the contract is binding, because in a unilateral offer, the offer is made to the world at large, and nobody who performs the specific condition accepts the offer. Here the advertisement is in the form of a unilateral offer. And the structure of word in the advertisement is not too vague and can be construed as a promise. Its formation is made in a way that leads the consumer to believe that if you use the smoke ball, you will not contract the flu for reasonable time after that. Third one is notification of acceptance not necessary. For contract to be valid, it is essential that when an offer is made, not only that it should be accepted, but that the acceptance should be notified. But in cases for this kind, there is no need to communicate the acceptance of an offer. The performance of the condition, that is using the smoke ball itself, amount to an acceptance of the offer. Let us talk about the concurring opinion on this. Justice Lidley concurred with the decision of Justice Bond and Smith, but the reasoning of Justice Bond for the notification of acceptance differed. For a contract to be valid, it is essential that when an offer is made, not only that should be accepted, but that the acceptance should be notified. but in the cases this kind, that rule is exception. Here the notification of acceptance need not precede the performance. And further in this is a continuing offer and was never repealed. So if any notice of acceptance is required, the person who makes the offer gets the notification of acceptance. So contemporaneously with the notice of the performance of the condition, to justify this, he used the rationale applied by the Lord Blackburn in the case of Brogden versus Metropolitan. The rule of law. The unilateral offer of the sale of goods via advertisement waives of the rule of notification of acceptance. An advertisement scheme with a reward for the performance of any act can be considered an express contractual promise to pay. So that's it. Thank you.